In 2017, former High Court Judge Justice Anup Singh Choudry took into consideration to apply for part of land in Namiiro Wetland in Entebbe Municipality, Wakiso District. According to Justice Choudry, following the legal processes gone through, the authorities of Entebbe Municipality granted him access and handed him the necessary documents for the required land with the purpose of using it for grape farming.
They inspected the land, they approved it, then they made an application to the Wakiso District Land Board.
Even so, having gone through all the processes, his request reaching the district level as the custodian of land was rejected.
So are all the culprits sitting there, hawks. They want to obstruct it. Left, right, and center. The most corrupt institution in the country. Right?
According to the Wakiso District chairperson, Matialwanga Bwanika, when the judge applied for the land, the district authority surveyed the land applied for and discovered that it was located in an ecologically sensitive area which would affect the environment, on top of being located in the vicinity of an aerodrome for Entebbe International Airport.
District Land Board subsequently rejected the application on the following grounds. Land in issue is located in an ecologically sensitive area. Hence, the need to seek the approval from the National Environment Management Authority. Point number B was that the Physical Planning Committee approval attached to the application contained the 5 plots, but the accompanying deed plans had 12 plots, implying that the application surveyed was in excess of the approved area.
Monica says that despite the outlined reasons for rejecting the application, the judge has been using his powers to get court orders forcing the District Land Board to issue titles without carrying out any visit to the land to ascertain the situation in which the district rejected these.
Strangely, despite the sensitivity of the land in issue and the clear rejection grounds, the retired judge has been granted many orders in his favor without court conducting any locus visit. First order issued by Honorable Justice Bone Isaac Ateko in miscellaneous cause number 135 of 2024 not only condemns the District Land Board to pay damages to the retired judge in excess of 400 million, but it also presents strange jurisprudence.
On top of that, the court went on to issue an order to the district to pay damages to the judge for the suffering, anguish and mental torture he has gone through ever since he showed interest in acquiring this land.
District Land Board pays punitive exemplary damages of 100 million to the applicant. If interest at 6% per annum shall apply to items C and D. Costs of the application have since been set at 150 million for mere miscellaneous application.
Despite the district efforts made to seek legal advice on this pending matter from the Attorney General, they have not received a response concerning the same.
If we are wrong, the custodian of the national law is the Attorney General. Is failing to come out since 2017 on this issue. And the court is ordering us to offer land to someone. To set aside these strange orders through the Attorney General's chambers have so far fallen on deaf ears, and the retired judge is moving faster than ever to enforce the judgment.
The district authority also accused the retired judge of having intentions to sell this particular public land to the Civil Aviation Authority.
Have it from reliable sources that the retired justice intends to sell this very land to Civil Aviation authorities for its intended airport expansion, since no private development can be permitted on that land.
The district has therefore written to the Ministry of Lands requesting for its urgent attention regarding the matter.
I appeal now to the Honourable Minister to find these developments a travesty of justice and broad derouting of land that by law is vested in government, to hold in trust for the benefit of every Ugandan citizen by the very people intended to act as guardians of the law.
However, according to the judge, he applied for a title for 30 acres, of which just part of this was found to be a wetland, and was advised by the Minister of Water and Environment to leave out this particular part, which he did.
Of lands, and the Attorney General, who are the custodians of that law, come and advise us. The moment they advise us that this is right, we shall do according to the law. But otherwise, our local findings are these, and we are wondering why all state agencies have kept quiet.
The land does not form part of the wetland. However, some plots Plot 15, plot 17, plot 19, plot 23, plot 25, and 27 have some overlaps into Namiiro Wetland. Upon that, also they granted him an objection letter to register his title, subject to resurveying and cutting off those portions.